Number 1. March of Varela. Every courtroom has a rhythm, a set of habits that regulars come to expect from the judge running it. In Luzerne County, Pennsylvania, the rhythm inside March of Varela's courtroom was simple and brutal. Kids came in. Kids got sent away. There was rarely a middle ground. March of Varela Jr. sat on the Luzerne County Court Common Pleas, and for years he built a reputation as a hardline judge who believed discipline was the answer to almost every problem a teenager could get into. Parents who walked into his courtroom assumed that whatever happened next would be rooted in the law, even if it felt harsh. What they did not know was that the harshness itself had become a business model. In the early 2000s, Varela and a fellow Luzerne County judge named Michael Conahan set in motion a plan that looked, on paper, like modernization. The county's own juvenile detention facility was defunded and eventually shut down. In its place came privately run detention centers, PA Child Care and Western PA Child Care, built by a developer named Robert Miracle and co-owned by an attorney named Robert Powell. These were for-profit operations, and for-profit operations only make money when beds are filled. That is exactly what happened. Between the two judges, more money flowed the harsher the sentences became. Investigators would later determine that Varela and Conahan received close to $2.8 million in payments connected to construction and use of these facilities, money that prosecutors said was funneled through finder's fees and other disguised transactions. The human cost was staggering. Kids as young as 10 and 11 were being sent to detention for offenses that, in almost any other courtroom in the country, would have ended in a warning or a bit of community service. One of the most well-known cases involved a teenage girl named Hillary Transu, who built a fake social media page mocking her assistant principal. She had no lawyer in the room and was never told she had the right to one. Varela sentenced her to 3 months at a wilderness camp. Her mother, who had spent 16 years working in child services for a neighboring county, assumed her daughter would get nothing more than a slap on the wrist. Instead, Hillary later described feeling completely disgraced, uncertain of how anyone would see her once she got out. Another case involved a young man named Kurt Kruger, who had never been in trouble with the law before he was accused of acting as a lookout while a friend shoplifted less than $200 worth of merchandise from a store. He pleaded guilty in front of Varela and ended up spending time in a company-run detention facility, followed by months at a wilderness camp run by a different operator. He later said he never imagined he would actually be sent away, and the experience derailed his education entirely. For years, complaints trickled in from families and defense attorneys, and advocacy groups raised concerns about unusually high detention rates in the county. Pennsylvania's Judicial Conduct Board actually received 4 separate complaints about Conahan between 2004 and 2008, but the board later admitted it never investigated a single one of them. The Federal Bureau of Investigation was tipped off in 2006 about Conahan and possible nepotism inside the county courts. Around the same time, a Philadelphia-based organization called the Juvenile Law Center began receiving requests for help from young people who had passed through Varela's courtroom. Attorneys there determined that hundreds of cases had been handled without the juveniles receiving proper legal counsel, and in 2008, they petitioned the Pennsylvania Supreme Court for relief. The real break came from an unrelated set of disciplinary hearings involving another Luzerne County judge and Lakuta, who was accused of misusing court staff and displaying open bias toward attorneys. During those hearings, Lakuta accused Conahan of orchestrating a conspiracy to have her removed from the bench, and she cooperated with a federal investigation that was quietly building against Conahan and Varela. In January 2009, the scheme finally became public. Prosecutors laid out how, starting around 2002, Conahan had used his authority as president judge to strip funding from the county's own detention facility while steering business toward the private centers he and Varela had a financial interest in. Both judges were accused of ordering juveniles into these facilities even when probation officers had not recommended placement at all. Initially, both men agreed to plead deals that would have kept their prison time to around 7 years. But the federal judge overseeing the case, Edwin Cossack, rejected those agreements in July 2009, saying that Varela and Conahan were still denying responsibility for their conduct even as the evidence against them piled up. That rejection blew the case wide open. A federal grand jury returned a 48-count indictment covering racketeering, fraud, money laundering, extortion, bribery, and tax violations. Conahan eventually pleaded guilty to one count of racketeering conspiracy. Ciavarella chose to fight the case at trial. In February 2011, a jury convicted him on 12 of the 39 counts he faced, including racketeering, honest services, mail fraud, tax violations, and conspiracy to launder money. He was acquitted of the extortion and bribery charges tied to a separate $1.9 million. Prosecutors said the two judges had extracted from the facility's co-owner. Right after the verdict, Ciavarella and his attorney stepped outside the courthouse for an impromptu press conference. It was interrupted by a woman named Sandy Fonzo, whose son had appeared before Ciavarella as a first-time offender and was sent to placement anyway. Her son later took his own life. She confronted Ciavarella publicly, her grief spilling out in front of the cameras. In August 2011, Ciavarella was sentenced to 28 years in federal prison. He was 61 years old at the time, meaning the sentence would very likely keep him behind bars for the rest of his life. He is currently held at a low-security federal facility in Kentucky, with a scheduled release date that would put him at 84 years old. He has continued to appeal parts of his conviction over the years, and in 2018 a federal judge actually threw out his convictions on the racketeering and money laundering conspiracy counts due to a statute of limitations issue, ordering a new trial on those specific counts while letting the fraud conviction stand. In October 2019, he was formally disbarred. Conahan received a lighter sentence of 17.5 years, in part because he pleaded guilty rather than going to trial. He was released to home confinement in 2020 during the coronavirus pandemic, and in December 2024, President Joe Biden commuted the remainder of his sentence as part of a broader set of commutations for people who had been on home confinement during the pandemic. That decision was heavily criticized by victims of the scandal and by Pennsylvania's sitting governor at the time, who called it absolutely wrong. The fallout from the case went far beyond the two men themselves. The Pennsylvania Supreme Court appointed a special master to review every juvenile case Ciavarella had handled, and the findings were damning enough that the court ordered roughly 4,000 adjudications from 2003 to 2008 vacated, with the affected records expunged. A class action lawsuit was filed against the judges, their spouses, business associates, and the companies involved. The developer who built the two facilities eventually agreed to pay around $25 million in settlements, and in 2022 a federal judge ordered Ciavarella and Conahan to pay a combined $206 million in damages to the roughly 300 juveniles affected. Pennsylvania's legislature created a special commission to investigate what had happened and to recommend reforms meant to protect the rights of juveniles going forward. Attorney Robert Powell and developer Robert Miracle were also convicted on related charges and served time of their own. The legal fallout stretched on for more than a decade after the scandal first broke. Using a rarely invoked legal authority known as King's Bench jurisdiction, dating all the way back to 1722, the Pennsylvania Supreme Court appointed a senior judge named Arthur Grimm to personally review every single juvenile case Ciavarella had handled. Grimm came back with a scathing interim report, concluding that because of Ciavarella's disregard for the constitutional rights of the young people who appeared before him, combined with the kickbacks driving his rulings, nobody who stood in his courtroom during those years had actually received a fair hearing. The court adopted his recommendation and vacated the affected adjudications. The civil side of the case was just as complicated as the criminal one. The Juvenile Law Center filed a class action on behalf of the juveniles who had been adjudicated without proper representation, and that case eventually pulled in the judges' spouses, their business associates, shell companies connected to the scheme, and officials from the youth centers themselves. In 2010, an injunction even had to be filed to stop the destruction of thousands of juvenile records that the defense argued it still needed. A federal appeals panel later ruled that the insurance company covering some of the defendants had no obligation to indemnify them, leaving the individuals and companies involved fully exposed to whatever judgments came next. Robert Miracle, the developer who built the two detention facilities, eventually settled his portion of the litigation for around $25 million, and in 2022 a federal judge ordered Ciavarella and Conahan to pay a combined $206 million in compensatory and punitive damages to the roughly 300 juveniles represented in the case, calculated using a rate of $1,000 for every day a child had been wrongfully detained. Miracle's own criminal sentencing was delayed for years, oddly enough, because prosecutors needed his testimony in an unrelated bribery case against a former Pennsylvania state senator. Once that case concluded, Miracle was sentenced to a single year in prison and a $250,000 fine, and he was released in 2015. Robert Powell, the attorney who co-owned the 2U facilities and had funneled roughly $770,000 in kickbacks to the two judges, served 18 months in a low-security federal facility and was later ordered to pay $4.75 million to settle claims tied to more than 2,400 juveniles affected by the scheme. The scandal even worked its way into popular culture. Filmmaker Michael Moore featured it in his documentary Capitalism, a love story, and a full-length documentary titled Kids for Cash was released in 2014 to strong reviews. A Pulitzer Prize-winning journalist wrote an entire book examining the case in detail, and it was later profiled on a network crime documentary series. Writers borrowed the outline of the scandal for episodes of several major television crime dramas, and at least one crime novelist built an entire book around a fictionalized version of the same events, transplanting it to a different state entirely. That a single county courtroom in northeastern Pennsylvania could inspire that much creative attention says something about how deeply this case unsettled people far outside Luzerne County. What makes this case so hard to shake is not just the scale of the money, although $2.8 million moving through a juvenile court is staggering enough on its own. It is the fact that thousands of children stood in front of a judge who had already decided, long before they walked in, that filling a bed somewhere was worth more than their future. Kids for Cash became the name the country gave the scandal, and it remains one of the most disturbing examples in modern American history of what happens when a courtroom stops being a place of justice and becomes, instead, a pipeline. Number 2, Michael Conahan. If Marcia Varela was a public face of the Kids for Cash scandal, Michael Conahan was the architect working behind the scenes. And in some ways his role reveals just how deliberately the entire scheme was built. Michael Thomas Conahan earned his law degree from Temple University and served on the Luzerne County Court of Common Pleas from 1994 to 2007, spending the final 4 years of that run as the court's president judge. That title mattered enormously because it gave him control over budgets, contracts, and administrative decisions for the entire county court system. Long before the Kids for Cash scandal broke, Conahan had already brushed up against serious allegations. In the 1990s, a man named Ronald Belichier was sentenced to prison time in connection with a cocaine trafficking ring, and a witness in that case testified that back in 1986, Conahan, then a magisterial district judge, had personally tipped off a drug connection that he was being investigated and allegedly referred him toward a different supplier. During a later court proceeding, a prosecutor described Conahan as an unindicted co-conspirator. When that detail became public in 1994, Conahan held a press conference to deny it, blaming the accusation on what he called common criminals looking for favorable treatment. Years later, once he had risen to president judge, Conahan used his budgetary authority to defund the county's own juvenile detention facility, clearing the way for a newly built, privately operated facility to take its place. Prosecutors allege he agreed to help generate at least $1.3 million a year in billable receivables in exchange for kickbacks from the facility's owner. Together with Varela, who controlled the sentencing side of the operation, Conahan helped build a closed loop. He made sure the private facilities had contracts and funding. Varela made sure those facilities stayed full. Just like with Varela, the Pennsylvania Judicial Conduct Board received 4 complaints about Conahan between 2004 and 2008 and failed to investigate a single one. The Federal Bureau of Investigation was tipped off in 2006 about possible nepotism connected to Conahan, and a separate investigation into sentencing practices in Luzerne County started gathering momentum in 2007 after the Juvenile Law Center began looking into complaints from young people who had passed through the county's juvenile system. The Lakuta disciplinary hearings once again played a pivotal role. Lakuta, another Luzerne County judge, was removed from the bench after being accused of misusing court staff and showing bias toward certain attorneys. During those same hearings, she accused Conahan of orchestrating her removal and testified that he had lied under oath about the judge's social relationships. It later came out that another judge involved in fixing cases, a along with a colleague, had stayed at a Florida condo jointly owned by Conahan and Ciavarella, directly contradicting Conahan's claim that the judges did not socialize outside of work. When the scheme finally surfaced publicly in January 2009, Conahan was indicted alongside Ciavarella. He initially pleaded guilty, then withdrew that plea with the intention of taking the case to trial, before ultimately pleading guilty a second time to one count of racketeering conspiracy in April 2010. In September 2011, Conahan was sentenced to 17 and a half years in federal prison. He was also ordered to pay restitution of roughly $874,000 to the state of Pennsylvania for the judicial salary he had drawn while running the scheme, along with a fine of just over $20,000. He had already forfeited his right to a state pension. At the conclusion of his sentencing hearing, he voluntarily surrendered to the custody of federal marshals. Because of concerns tied to coronavirus pandemic, Conahan was released from prison in June 2020 and placed on home confinement, roughly 6 years earlier than his sentence would have otherwise allowed. His anticipated release date under that arrangement was 2026. Instead, in December 2024, President Joe Biden commuted the remainder of his sentence entirely as part of a mass commutation covering more than 1,500 people who had been on home confinement during the pandemic. The reasoning given was that many of these individuals would likely have received shorter sentences under current sentencing guidelines and had shown they deserved a second chance. The decision was immediately criticized by victims of the Kids for Cash scandal, who felt that Conahan's crimes were categorically different from a typical nonviolent offense, and by Pennsylvania's governor, who publicly called the commutation absolutely wrong. The broader consequences of the scandal were sweeping. The Pennsylvania Supreme Court was forced to vacate thousands of juvenile convictions tied to Ciavarella's courtroom. A state interbranch commission on juvenile justice was created specifically to study what had gone wrong and recommend changes to protect the constitutional rights of young people going forward and to improve how judicial misconduct gets investigated in the first place. The American Bar Association later reviewed the case and made its own recommendations for improving Pennsylvania's Judicial Conduct Board, the same body that had ignored for separate complaints about Conahan for years before any of this became public. The original charges filed against Conahan and Ciavarella in January 2009 covered honest services mail and wire fraud, along with tax fraud tied to the use of the privately owned detention facilities. Both men initially agreed to plead guilty, but Judge Kosick rejected those plea agreements in July 2009, ruling that neither man had truly accepted responsibility for what they had done. That rejection forced prosecutors back to grand jury, and in September 2009, and again in September 2010, they returned superseding indictments that added racketeering, additional fraud counts, money laundering, extortion, bribery, further tax violations, and conspiracy. The government also sought forfeiture of roughly $2.8 million in assets it said the two men had acquired through racketeering and money laundering. A recent United States Supreme Court decision at the time, in a case called United States v. Skilling, had narrowed how prosecutors could bring honest services fraud charges. And the 2010 indictment was specifically rewritten to make clear that actual bribes and kickbacks, not just a vague breach of trust, were at the center of the case against both judges. Federal investigators called this the largest and most sustained political corruption inquiry in the history of the Middle District of Pennsylvania. What began in 2007 as a narrow look at improper sentencing eventually expanded to touch county government offices, state legislators, school districts, and contractors across northeastern Pennsylvania. By the time it wrapped up, more than 30 local or state government officials and contractors connected to the broader web of corruption in Luzerne County had either been convicted or were awaiting trial. Conahan may not have been the one handing down sentences in the courtroom, but without his administrative maneuvering behind closed doors, none of it would have been possible in the first place. There is something particularly unsettling about Conahan's role compared to his partners. Ciavarella was the one families saw. He was a face in the room, the man reading out sentences, the person parents would point to and say, "That is who did this to my child." Conahan mostly worked in the background, moving budgets, closing facilities, negotiating contracts, doing the quiet administrative work that made the entire scheme financially possible in the first place. It is a useful reminder that corruption inside an institution rarely comes from just one person. It usually takes at least two, one who is willing to hand down the harm directly, and another who is willing to build a structure that makes handing down that harm profitable. Take away either man, and the entire scheme collapses. Conahan built the machine. Ciavarella ran it. And for years, nobody in a position to stop either of them did. Number 3, Paul Pozanski. Not every judge who ends up on a list like this got caught taking bribes. Some simply could not resist the very thing they were sworn to keep locked away. Paul Pozanski built a long career in Washington County, Pennsylvania, starting as a magisterial district judge in 1983 before winning election to the county's Court of Common Pleas in 1997. He was, by most public measures, a well-respected figure. He served on the Ethics Committee of the Pennsylvania Conference of State Trial Judges for 9 years. In 2004, he partnered with the county's district attorney to establish the county's very first drug treatment court, a program built around the ideas of helping addicts recover rather than simply locking them away. He won a retention election in 2007 with strong support from the State Bar Association. Back in 2004, in a ruling that raised eyebrows even at the time, Pozanski dismissed 51 charges against a driver whose license had been suspended for 30 years, a sign, in hindsight, that he had never been shy about bending the ordinary rules of his courtroom when it suited him. In 2011, he presided over a civil case involving a family who alleged their health had been damaged by hydraulic fracturing wells drilled next to their property, a case involving several gas wells, a compressor station, and a large wastewater pond next to their small farm. That case settled for $750,000, but Pozanski barred the media from his courtroom during proceedings and sealed the entire settlement file, despite repeated efforts by reporters to have the details released. His position gave him broad authority over criminal trials, summary appeals, juvenile treatment court, and drug treatment court, which many had regular access to narcotics evidence being held for active cases. For years, nothing seemed unusual about that access. Then, in May 2012, the county's president judge suspended his drug treatment court entirely. A week later, she stripped him of his criminal caseload altogether, reassigning him to civil cases and non-jury trials. Before that point, Pozanski had been responsible for as much as 70% of the county's entire criminal docket. Shortly after those administrative moves, Pozanski left for what he described as a 2-week trip to Alaska, where his wife had family. By the end of June, he had resigned from the bench, citing conversations with and the needs of his family. Within weeks, his attorney confirmed that the Pennsylvania Attorney General's office was investigating him. While the investigation was ongoing, Pozanski was hired as a workers' compensation hearing officer in Alaska, a position he secured after the filing deadline had technically already passed, and without holding the residency preference normally expected for the opening. His wife's family had deep political connections in the state, including a brother-in-law who had briefly served as a state public safety commissioner and later worked on staff for a sitting United States senator, along with other family ties to Alaska's Commission on Judicial Conduct and a former lieutenant governor. Questions swirled about how Pozanski landed the job at a pay rate notably higher than what had originally been advertised. Alaska's governor at the time ordered his own investigation into the circumstances of the hire, but the administration denied media requests for correspondence related to the matter, citing personnel privacy exemptions, and the investigation produced little public clarity before Pozanski resigned from the position by the end of 2012 under mounting pressure. Around this same period, his second wife filed for divorce, a case that became final later in 2015. Back in Pennsylvania, investigators pieced together what had actually happened in his old courtroom. Roughly 291 grams of cocaine tied to active criminal cases had gone missing, been tampered with, or been swapped out for baking soda. Pozanski was formally charged in May 2013 with stealing cocaine from evidence, along with numerous related offenses. He claimed to have personally destroyed additional missing drugs and cash on his own initiative, though those specific losses were never separately charged. He also challenged the legality of the search of his former judicial office, a search that had uncovered much of the evidence against him. In March 2015, he reached a plea agreement, pleading guilty to 3 of the 6 counts in his indictment. Prosecutors did not push for jail time as part of that arrangement. At sentencing, The prosecutor told the court that Pazanski had effectively turned the courthouse into what he called his own stash house, using law enforcement as an unwitting private supplier, and criticized him for continuing to serve on the bench even after entering drug rehabilitation himself. In July 2015, Pazanski was sentenced to a range of 30 days to 23 and a half months in jail, along with 2 years of probation. He was given work release almost immediately and was released from jail entirely by mid-August of that year. He also forfeited a pension worth roughly $98,000 a year, along with his lifetime health benefits. The Pennsylvania Supreme Court suspended his law license days later, and in January 2018, the court ruled 5-2 to permanently disbar him, rather than simply suspend him, as his attorneys had requested. One justice, writing for the majority, said his conduct had turned the legal proceedings he once presided over into what she called a shame and a farce. Another justice noted that Pazanski had never actually presented medical evidence tying his conduct to an addiction, which might otherwise have supported a lesser penalty. What makes this case unusual compared to some of the others on this list is the sheer intimacy of the betrayal. Pazanski was not skimming money from a distant contractor or steering cases toward a business partner. He never had a look in the eye. He was reaching directly into the evidence lockers of the very court system he ran, quietly replacing what belonged to the state with something worthless, all while sending other people to jail for the exact substance he was consuming himself. Consider the defendants who passed through his drug treatment court during those years. People who were told that the system wanted to help them get clean, that the judge overseeing their recovery understood the disease of addiction and was invested in their success. Some of those same defendants had their cases built on evidence that Pazanski himself was quietly siphoning off for his own use. Prosecutors were later forced to either drop charges entirely or renegotiate plea deals in cases where the chain of evidence had been compromised, which means some of the same people Pazanski sentenced to treatment programs ended up walking free. Not because the courts decided they were innocent, but because the judge who was supposed to be holding the whole system together had hollowed it out from the inside. Number 4, Tim Nolan. Some of the men on this list hid their crimes behind complicated financial schemes. Tim Nolan did not need one. He simply used decades of accumulated trust and community standing as a weapon against people with almost no one else to turn to. Timothy Lee Nolan earned undergraduate degrees in philosophy and geology from Thomas More College before completing his law degree at Salmon P. Chase College of Law at Northern Kentucky University. Early in his career, he served as city solicitor for Newport, Kentucky, and from 1978 to 1986 he sat as a state district court judge in Campbell County. After leaving the bench, he stayed deeply embedded in local politics and law for decades, eventually becoming one of the leaders of the Campbell County Republican Party. In 2016, he named himself the county chairman of a presidential campaign in his region, and he was briefly appointed by Kentucky's governor to the state's first boxing and wrestling commission before being removed within days over controversy tied to a social media post. He also won a seat on the Campbell County School Board that same year. Nolan had a long history of being an outspoken and controversial figure well before any of the criminal allegations surfaced. He unsuccessfully ran for a seat on the Kentucky Supreme Court back in 1982, losing in the primary. Decades later, as a member of the Republican Party aligned with the Tea Party movement and eventually with Donald Trump's campaign, he was often at odds with the party's own leadership in Kentucky. In April 2016, he attempted to have Senate Majority Leader Mitch McConnell removed and replaced as a delegate to that year's Republican National Convention, arguing that McConnell had not done enough to support Trump's candidacy, a move that drew attention across the state's political press. None of that public activity gave any indication of what investigators would eventually uncover. In 2017, a woman went to police and reported that Nolan had threatened her with jail time if she did not comply with his demands. That single report opened the door to a much larger investigation, and once detectives started interviewing people, they found a disturbing pattern repeating itself across multiple accounts. According to prosecutors, Nolan targeted women who were in genuinely desperate circumstances, some homeless, some struggling with substance dependency, others simply trying to stay out of legal trouble. He offered them money, housing, or help navigating the court system. In exchange, he used threats and coercive pressure, warning victims of his history in law enforcement, and the courts meant he could destroy their lives if they refused him. The The Kentucky Attorney General's office ultimately built a case that included charges of human trafficking, witness tampering, unlawful transactions with minors, prostitution-related offenses, and retaliation against people who came forward against him. Some of the conduct prosecutors documented stretched back to 2004. By the time he was arrested in May 2017, Nolan was 70 years old and had resigned from the school board just 2 days after being indicted on 9 felony and 2 misdemeanor counts. In total, he ultimately faced 28 felony charges tied to 22 identified victims, 8 of whom were minors. Nolan initially pleaded not guilty to everything. But in February 2018, at the age of 71, he changed course and pleaded guilty to 19 counts, some through an Alford plea covering conduct going back to 2004 and involving 19 separate victims. The agreement called for 20 years in prison, along with a $100,000 fine. According to the counts he admitted to, his conduct involved human trafficking, supplying drugs and alcohol to minors in exchange for sexual acts, and threatening victims with arrest or eviction if they refused to comply. He was sentenced to 20 years in prison and sent to a Kentucky correctional facility. Given his age at sentencing, there was little realistic chance he would ever again hold any position of public trust. What stands out about Nolan's case is how long his community shielded him without ever suspecting a thing. He held elected office, sat on a school board, chaired a presidential campaign in his region, and was seen as a respected, if outspoken, figure in local politics for decades. All of that public visibility, all of that accumulated legitimacy, became exactly the tool he used to convince his victims that no one would believe them if they spoke up. That is often how this kind of predation actually works in the real world. It rarely looks like a stranger in an alley. It looks like someone with a title, someone with connections, someone the community has already decided to trust long before any of the victims ever meet him. Several of the women who eventually testified said they had specifically been afraid to report Nolan for years precisely because of his past as a judge, worried that his history inside the legal system meant he could manipulate the outcome even from the outside. It took one person walking into a police station and refusing to stay quiet to unravel a pattern that, according to prosecutors, had been running for well over a decade. Number 5, Dawn Gentry. Dawn Gentry's downfall did not involve stolen money or a secret business deal. It involved something quieter and, in its own way, just as corrosive, an entire courtroom bent to serve one person's personal and political interests. Gentry was appointed to the Kenton Family Court of Kentucky's 16th Judicial Circuit by Governor Matt Bevin in December 2016, and she went on to win a full term to the seat as a Republican in November 2018. She held a law degree from Northern Kentucky University and had practiced family law and Social Security disability law before joining the bench. Her court handles some of the most sensitive matters a judge can oversee: divorces, child abuse and neglect cases, and truancy proceedings involving families already in crisis. In December 2019, the Kentucky Judicial Conduct Commission filed misconduct allegations against her covering 9 separate counts. Gentry denied the accusations in her formal response. In January 2020, the commission suspended her without pay while the investigation continued, and by February, Kentucky's General Assembly had formed its own committee to explore whether grounds existed to impeach her. That legislative effort stalled out when the Assembly session ended in April 2020 due to restrictions tied to the coronavirus pandemic, before the impeachment investigation could be completed. Her disciplinary hearing, originally scheduled for April 2020, was pushed back to August because of the pandemic. In the meantime, the commission was not done adding to the case against her. In July 2020, it filed 3 additional misconduct charges, bringing the total scrutiny on her conduct to 12 separate counts. What emerged through the investigation painted a picture of a courthouse run less like a judicial office and more like a private social circle where loyalty mattered more than professionalism. Investigators and witnesses described Gentry storing and consuming alcohol inside court offices and engaging in inappropriate personal conduct on courthouse property. She was accused of firing a staff member specifically to create an opening for her own pastor and romantic partner, whom she then allowed to play guitar and sing during working hours. One attorney alleged that Gentry pressured her for a sexual relationship and then retaliated professionally when she refused. She was also accused of pressuring court staff into doing campaign work for her re-election during official working hours, and of bringing her own children into the courthouse where they were exposed to confidential and sensitive family court proceedings. In August 2020, the Kentucky Judicial Conduct Commission found Gentry guilty on 10 to 12 counts, covering sexual misconduct, judicial misconduct, and campaign finance violations. She was permanently removed from the bench. Gentry appealed the ruling in September 2020, but the Kentucky Supreme Court upheld her removal later that year. In 2022, after she expressed remorse and acknowledged that alcohol use had played a role in her conduct, the Kentucky Supreme Court suspended her law license for 4 years rather than disbarring her outright. Unlike several of the other cases on this list, Gentry never faced criminal charges. There was no bribery scheme, no stolen evidence, no financial kickback trail for prosecutors to follow. What ended her career instead was a pattern of favoritism, coercion, and retaliation that turned an entire courthouse into an extension of her personal life. For the families who depended on her court to handle some of the most painful moments of their lives with basic fairness, that was more than enough to shatter their trust completely. It is worth sitting with just how much authority a family court judge actually holds over people who appear in front of them. These are not abstract disputes over property or contracts. These are custody battles, allegations of abuse, decisions about which parent a child goes home with at the end of the day. When the person making those decisions is more focused on rewarding loyalty and punishing disagreement than on weighing the facts of each case, the people who suffer are rarely the attorneys or the staff caught up in the political games. They are the parents and the children whose futures were being decided inside that same building by someone whose attention was somewhere else entirely. Before we move on to the back half of this list, it's worth pausing for a second on what we've covered so far. 2 Pennsylvania judges who built an entire financial pipeline out of locking up children. A 3rd Pennsylvania judge who stole the very drug evidence he was supposed to be safeguarding. A Kentucky judge who spent decades building political credibility, only to use it as a weapon against some of the most vulnerable people in his community. And a family court judge whose courtroom turned into a personal fiefdom built on loyalty rather than law. 5 cases in, and already we've seen almost every possible motive behind judicial corruption, money, addiction, predation, and plain unchecked ego. The back half of this list is not going to look much different, but each case still manages to reveal its own version of how badly things can go wrong when nobody is watching the person doing the watching. Let's keep going. Number 6, Tracy Hunter. Tracy Hunter's story is, in many ways, a story about how far someone will go to protect their own family, and how that instinct, when combined with judicial power, can spiral into a criminal conviction. Hunter earned her law degree from the University of Cincinnati College of Law and was admitted to the Ohio bar in 1993, spending years afterward as an advocate for neglected children and as a contract attorney with the Public Defender's Office, while also working as a general manager of an urban gospel radio station. In 2010, she ran for a seat as Hamilton County's juvenile court judge and initially appeared to lose the race by roughly 3,000 votes. Her campaign identified serious issues with how a batch of provisional ballots had been counted and filed a federal lawsuit over the results. A federal judge ruled that the apparent winner should not take office until the provisional ballot dispute was resolved, and the fight over those ballots dragged on for well over a year, even reaching the United States Supreme Court, which declined to hear it and sent the matter back down to the district court. At one point, Ohio's Secretary of State ordered the results certified without the disputed ballots being counted at all, only for the federal judge overseeing the case to order more than 150 of those ballots counted after finding they had likely been affected by poll worker error. During the months the case was pending, Ohio's governor appointed Hunter's opponent to the seat anyway, making him senior judge while the litigation continued. More than a year after Election Day, following the court-ordered recount, Hunter was declared the winner by just 71 votes and was sworn in during May 2012, becoming the first woman and the first African-American to hold that position in Hamilton County. During her time on the bench, Hunter pushed through a number of reforms, banning the shackling of juveniles in her courtroom, working to change state election law to allow former felons to vote, and increasing staff training within the court, along with adding additional transportation for offenders to reduce overcrowding in transport vehicles. She often described her focus as being on rehabilitation rather than incarceration. She also drew criticism for restricting media access to certain juvenile cases and for a growing backlog of undecided cases, an issue that put her on a collision course with the appeals court overseeing her docket. One case in particular became a flashpoint for that criticism. In August 2012, 6 middle school football teammates admitted to police that they had severely beaten a stranger in a Cincinnati suburb, telling investigators they had done it simply because they were bored. Hunter placed the defendants, who had all pleaded guilty, on house arrest with community service while she considered her ruling, and she moved to shield their identities from media coverage, arguing it would reduce the odds of them reoffending later in life. Local newspapers and television stations sued to overturn the restriction and won in court, but Hunter continued to resist complying. The case dragged on for so long that it still had not been resolved by the time Hunter was removed from the bench, and it was eventually decided by a different judge in 2014, more than a year after the original attack, and, tragically, after the victim himself had died from complications connected to the assault. Things began to unravel in 2013 when county prosecutors raised concerns about documents in her courtroom that appeared to have been backdated. A private company responsible for the court's computer systems determined that 2 documents, filed and signed by Hunter, had not actually been created until weeks after the dates listed on them, a discrepancy that would have prevented prosecutors from filing timely appeals of her rulings. Special prosecutors were appointed to look into the allegations. In January 2014, a Hamilton County grand jury indicted Hunter on 8 felony counts, including evidence tampering, forgery, theft in office, and having an unlawful interest in a public contract. The most serious of these charges centered on her brother, Stephen Hunter, who worked as a corrections officer at the Court Youth Center and had been accused of hitting someone in his custody. Just before her brother's disciplinary hearing, Tracy Hunter allegedly demanded that the youth center superintendent hand over all documentation related to every incident and every employee connected to the case. She then passed those documents on to her brother, who gave them to his own attorney, who reportedly declined to use most of them, calling the situation unethical. The Ohio Supreme Court immediately disqualified Hunter from serving as a judge on the same day she was indicted. At trial, her defense argued that the documents in question were part of the public record anyway, and that her actions were not improper. The jury disagreed on that specific point. In October 2014, jurors found her guilty on the single count of having an unlawful interest in a public contract, while deadlocking on the remaining 7 charges, which were later dismissed. The presiding judge admonished her at the reading of the verdict for what he described as serious ethical violations during her time on the bench, including nepotism and improper judicial temperament. A week later, the Ohio Supreme Court suspended her license to practice law, and in December 2014, she was sentenced to 6 months in jail, 1 year of community service, and payment of the court's costs. Hunter fought the sentence for years, exhausting her appeals only in 2019. At the conclusion of that final appeal hearing, she refused to cooperate with court officers and had to be physically dragged out of the courtroom by a bailiff, a moment captured on camera that drew national attention. She finally served her sentence in 2020, spending roughly 75 days in jail, paying around $34,000 in court costs, and completing her required community service. In the years that followed, Hunter pursued reinstatement of her law license. In 2023, the Ohio Board of Professional Conduct recommended she remain indefinitely suspended, and she appealed that decision to the Ohio Supreme Court, representing herself and arguing that she had not actually committed the crime the jury convicted her of. The court upheld the suspension in November 2023, though it credited her with 9 years of interim suspension time already served, which made her immediately eligible to apply for reinstatement going forward. Throughout the entire ordeal, Hunter maintained that she had been targeted for political and racial reasons, a claim her supporters echoed loudly at the time of her removal. Whatever the full truth behind the motivations of everyone involved, the jury's verdict and years of appeals that followed left her with a permanent felony conviction and an ended judicial career. Closing the book on a tenure that had begun as a genuine milestone and ended in one of the more visually striking courtroom scenes in recent memory. What makes Hunter's story so difficult to file neatly into one category is that it genuinely holds 2 things at once. She was, by the historical record, a trailblazer who pushed through real reforms meant to protect juveniles in her courtroom. She was also according to a jury of her peers. Someone who used her office to obtain confidential information for a family member facing discipline of his own. Those two facts do not cancel each other out. They simply sit next to each other, a reminder that judicial misconduct does not always come wrapped in a simple, easy-to-hate package. Sometimes it comes from someone who did plenty of good on the bench, right up until the moment their own family was on the line. Number 7. Herman Thomas. Herman Thomas spent years building a reputation as one of the few black judges in Alabama at the time he took the bench, a fact that made him something of a symbol of progress in a region with a long and complicated legal history. What eventually came out about his private conduct made that symbolism far more complicated. Thomas served as a circuit judge in Mobile County, Alabama, presiding over criminal cases involving defendants who often had few resources and even less leverage to push back against him. In 2007, at his own request, he became the focus of a formal investigation by the Alabama Judicial Inquiry Commission, which ultimately charged him with 30 separate violations of judicial ethics. Some of those allegations involve him improperly helping friends and family members with their own legal troubles, including reversing or reducing sentences that other judges had already handed down. In one documented case, his fraternity brother and relative, a school board president, was charged with a DUI after running over an 8-year-old girl's foot during Mardi Gras. Thomas granted the early return of his driver's license and helped arrange his transfer between jails. At the same time, a separate and far more serious set of allegations was surfacing. A number of young men who had been held at the Mobile County Metro Jail claimed that Thomas would personally check them out of custody, take them to a private room inside the courthouse after hours, and physically paddle them. 4 men signed affidavits as part of a federal lawsuit alleging that Thomas attempted to initiate sexual encounters with them and threatened retaliation in their pending criminal cases if they refused to comply. The president of Mobile's chapter of the NAACP, who was also the brother of Thomas's longtime secretary, publicly questioned whether racial motives were behind the investigation, and the organization said it planned to file its own complaints with federal authorities, including the Department of Justice, requesting a review of how the local prosecutor's office was handling the matter. That tension over how the case was being framed publicly ran alongside the investigation for years, with supporters arguing Thomas was being unfairly singled out and accusers insisting the pattern of conduct described across multiple independent accounts spoke for itself. In 2009, Thomas was indicted on criminal charges that included sex abuse, extortion, and sodomy. His law license was suspended that same year following the indictment. At trial, the jury returned not guilty verdicts on some counts and deadlocked on others, which the presiding judge then dismissed, resulting in a full acquittal on the criminal charges. Even though he avoided a criminal conviction, the ethics case against him moved forward on a separate track. In 2010, the Alabama State Bar disbarred Thomas specifically over what it described as sexually motivated assaults, with a disbarment structured so that he could theoretically petition to have his license reinstated after 5 years. The Alabama Supreme Court upheld that disbarment in November 2010. He had already resigned from the bench before the criminal trial began, choosing to step down rather than face a forced removal through the judicial ethics process. Thomas attempted a political comeback that same year, running unsuccessfully against an incumbent for a Democratic state Senate nomination, with the backing of Alabama's oldest black political organization. His case sits in an uncomfortable space precisely because the criminal system and the ethics system reached 2 different conclusions. A jury, working with the higher burden of proof required in a criminal trial and relying heavily on the testimony of inmates with their own legal troubles, declined to convict him. The Bar Association and the judicial ethics process, working with a different standard of evidence, found enough to permanently strip him of his ability to practice law. Whichever system you trust more, the underlying pattern described by multiple men, independently, about being pulled out of custody and taken to a private room with no witnesses present, was disturbing enough to end his career either way. This case also raises a question that shows up again and again throughout this list, which is what accountability is even supposed to look like when the criminal system and the professional system disagree with each other. An acquittal in a criminal courtroom means the government failed to prove guilt beyond a reasonable doubt. It does not mean the underlying conduct never happened. Thomas walked away from his criminal trial a free man, but he never walked back into a courtroom as a judge, and the state bar's decision to permanently take his license, rather than simply suspend it, tells you which version of events the people closest to the evidence actually believed. Number 8. Sherry K. Stevens. Not every judge on this list broke the law themselves. Sherry Stevens never faced criminal charges, was never accused of taking a bribe, and never lost her license. What put her name into the national conversation was the way she wielded the discretion that comes built into the job, and the years of controversy that followed her because of it. Stevens was appointed to the Maricopa County Superior Court in Arizona in 2001 by Governor Jane D. Hull, and served on the bench for 20 years before retiring in August 2021. She became a household name because of a single case, the 2013 murder trial of Jodi Arias, accused of killing her ex-boyfriend Travis Alexander, a case that captured global attention because of its graphic details and its extensive live television coverage. Alexander had been shot in the head, stabbed 27 times, and had his throat slit. Arias admitted before trial that she had killed him, but claimed she acted in self-defense, while prosecutors argued the killing had been premeditated. Stevens denied a defense motion to take the death penalty off the table, meaning Arias faced capital punishment throughout the proceedings. Arizona is one of the few states that allows jurors to directly question witnesses during a trial, and Arias fielded an enormous number of questions from the jury box over the course of the case, though no strong evidence ultimately emerged to support her claim of self-defense. On May 8, 2013, the jury found Arias guilty of first-degree murder. 2 weeks later, a mistrial was declared on the sentencing phase after the jury failed to agree on whether she should receive the death penalty. Stevens later granted a request to ban live television coverage of the retrial on sentencing and prohibited electronic devices in the courtroom, preventing reporters from live tweeting updates as the case unfolded. She denied other requests from the defense, including a bid to move the trial out of Maricopa County and a request to sequester the jury. Parties in the case returned to Stevens' courtroom for a closed hearing in May 2014, and a retrial on sentencing was originally scheduled for that September, before being pushed back, with jury selection ultimately beginning at the end of that month. In March 2015, Stevens declared a second mistrial after that jury also failed to reach a unanimous decision, this time with just one juror refusing to agree to a death sentence. That single holdout meant the death penalty was permanently removed as a sentencing option, and Arias was ultimately sentenced in April 2015 to natural life in prison with no possibility of release. The lone juror who blocked the death sentence faced significant backlash once her identity was leaked online, including death threats from people angry about the outcome. Beyond the Arias case, Stevens faced broader criticism throughout her career from defense attorneys and defendants who accused her of consistently favoring prosecution arguments, shutting down defense motions without what they considered proper consideration, and creating an atmosphere in her courtroom where outcomes sometimes felt predetermined before anyone had finished making their case. Former staff and attorneys describe her as quick to hold people in contempt over minor disruptions, and some attorneys said they tried to avoid appearing before her altogether because of how they believed their clients would be treated. Critics also pointed to lengthy delays in some of her cases, arguing that continuances were sometimes used as leverage rather than out of genuine legal necessity, and to a pattern of closed proceedings that made it harder for the public to evaluate whether her rulings were fair. Stevens was never criminally charged and never disciplined to the point of losing her position. She served out her full 20-year tenure and left the bench on her own terms through retirement. Her case is a reminder that not all judicial controversy involves cash changing hands or evidence disappearing from a locker. Sometimes the damage comes from the slow accumulation of discretionary decisions, made entirely within the bounds of what the law allows a judge to do, that nonetheless leave people feeling like the process itself was never really neutral to begin with. There is a particular kind of frustration that comes from a case like this one, which of Varela or Maggio, there's a clear moment where a line was crossed, a bribe accepted, a check cashed, something concrete a prosecutor could point to and say, here's a crime. With a judge like Stevens, there is no single moment like that. There is only a pattern, spread out across 2 decades in countless individual rulings, each one defensible on its own, each one falling within a judge's normal discretion, that together left a long list of attorneys and defendants describing the same feeling, that the outcome in her courtroom often felt decided before anyone had finished speaking. Number 9, Michael Maggio. Michael Maggio's case is a study in how quickly a single afternoon of poor judgment, timed just right, can unravel decades of career. Maggio grew up between Louisiana, Texas, and Mississippi before eventually completing his law degree at the University of Arkansas at Little Rock. He worked as a deputy prosecutor and a small claims judge before Arkansas Governor Mike Huckabee appointed him as circuit judge for the 20th Judicial District in 2000. He went on to win re-election twice, remaining on the bench until his removal in 2014. Early in his career, he was even named to a local business publications list recognizing young professionals under 40. In October 2010, the Arkansas Ethics Commission fined Maggio and issued him a public letter warning for paying his wife out of campaign funds and misreporting how that money had been spent during his 2008 re-election campaign, an early sign of the boundaries he was willing to cross. The case that ultimately brought him down began in May 2013, when Maggio presided over a jury trial involving the family of a woman named Martha Bull, who had entered a nursing home for what was supposed to be a short rehabilitation stint following a mild stroke, and died less than 2 weeks later after staff failed to get her to a hospital despite her screaming in pain. The jury awarded her family $5.2 million in damages against the nursing home. The very next month, Maggio announced he was entering a race for a seat on the Arkansas Court of Appeals. In July 2013, Maggio held a hearing on the nursing home's motion to reduce that judgment. On the same day as that hearing, the office of Michael Morton, the owner of a large chain of nursing homes, including the one at the center of the case, cut checks worth $30,000 to political action committees controlled by a lobbyist named Gilbert Baker, funds that Baker intended to funnel into Maggio's Court of Appeals campaign. The following day, Maggio received $24,000 in campaign donations. The day after that, he reduced the jury's $5.2 million verdict down to $1 million, cutting more than 80% of what the jury had originally awarded. Separately, in March 2014, a blog publisher revealed that Maggio had made a series of online posts on a website devoted to college football using an anonymous profile, in which he discussed a sealed case in his own courtroom involving a closed adoption by a well-known actress, along with a number of other posts containing racist, sexist, and explicit language. Once the connection to Maggio became public, he admitted to writing the post within days and withdrew from the Court of Appeals race entirely. In September 2014, the Arkansas Supreme Court issued an opinion immediately removing Maggio from the bench, concluding that immediate removal was the only just and proper response to his conduct. The Federal Bureau of Investigation, which had begun investigating him earlier that year, eventually built a case connecting the timing of Morton's campaign contributions directly to the timing of the reduced verdict. In January 2015, Maggio pleaded guilty to accepting a bribe in exchange for reducing the judgment in the Bull case. He later tried, unsuccessfully, to withdraw that guilty plea, appealing the matter all the way up to the United States Supreme Court without success. Maggio was sentenced to 10 years in federal prison, the maximum term available, and began serving that sentence in July 2017. In testimony he gave years later during the federal trial of Gilbert Baker, who was charged as a middleman in the bribery scheme, Maggio admitted under oath that he had reduced the verdict partly because he believed it was the right thing to do and partly because he had accepted a bribe to do it. Baker was ultimately acquitted on the core bribery conspiracy charge, with jurors deadlocking on the remaining counts against him, and Baker was scheduled for a retrial that was postponed more than once by agreement between his attorneys and prosecutors. Jury selection for that retrial was set to begin the day before an Arkansas general election, in which the only related figure on the ballot was a state Supreme Court justice who was a close friend and collaborator of Maggio's. Baker had also raised campaign money for that justice's own Supreme Court race back in 2014, collecting tens of thousands of dollars from the same nursing home owner connected to the original bribery scheme. Rather than proceed to that retrial, federal prosecutors ultimately asked for the remaining charges against Baker to be dismissed entirely. Maggio was released from federal prison in October 2021 after serving 4 years of his 10-year sentence. In 2022, a federal judge granted an early end to his supervised release. He later filed a motion seeking to have his conviction expunged, which was denied in 2023, and his subsequent appeals to the federal court system, including one final attempt at the United States Supreme Court, were all rejected. What makes the Maggio case so striking is the precision of the timeline. A hearing on reducing a verdict, a batch of campaign checks cut that same day, a wave of campaign donations the next day, and a slash judgment the day after that. It took investigators time to connect those dots, but once they did, the sequence spoke for itself far more clearly than any single piece of testimony could have. It is also worth remembering who was actually on the other side of that reduced verdict. Martha Bull went into that nursing home expecting a short rehabilitation stay after a mild stroke. She died less than 2 weeks later after staff ignored her screams of pain. A jury of Maggio's fellow Arkansans looked at that set of facts and decided her family deserved $5.2 million. It took a handful of political action committee checks, cut over the span of 2 days, for Maggio to decide that number was worth cutting by more than 80%. Behind every one of these financial corruption cases is a real family who trusted a jury's verdict, only to watch it get quietly rewritten by the one person in the room who was supposed to have no stake in the outcome at all. Number 10, John C. Roach Jr. John Roach's career stands apart from most of the names on this list, because on paper, it reads like a genuine success story right up until the very end of it. Roach grew up in Frankfort, Kentucky, and studied at Washington and Lee University before attending the University of Kentucky College of Law, where he graduated in the top 5 of his class, served as an editor of the Kentucky Law Journal, and was inducted into the Order of the Coif, one of the legal profession's most selective academic honors. After law school, he clerked for a judge on the United States Court of Appeals for the Sixth Circuit, then worked at a major law firm in Washington, D.C., before joining Lexington, Kentucky firm where he made partner. Before ever putting on a robe, Roach served as general counsel to Kentucky Governor Ernie Fletcher. In June 2005, at just 38 years old, Fletcher appointed him as a justice of the Kentucky Supreme Court, representing the state's 5th Judicial District. His term ran only through the end of 2006, and when he ran for a full 8-year term that November, he lost the election to Judge Mary Noble. After leaving the state's highest court, Roach returned to private practice, eventually becoming a partner at a Lexington law firm. He went on to serve as general counsel again during the transition of a later Kentucky governor, built a wide-ranging commercial litigation and appellate practice, and became particularly well known within the world of thoroughbred horse racing law, representing clients across breeding and racing transactions. His client list over the years reportedly included a major automobile manufacturer's Kentucky manufacturing operation, a regional hospital, a large shopping center developer, and a well-known restaurant franchise group. He was named to a national list recognizing top American lawyers for a number of consecutive years and received a top peer review rating from a major legal rating service. He eventually served as vice chairman of the Kentucky Horse Racing Commission, and among the equine transactions he is most associated with is serving as lead counsel in the stallion syndication of Pioneer Off the Nile, the sire of a horse that went on to win the Triple Crown and a Breeders' Cup Championship. The available record does not describe Roach as having faced a criminal conviction or formal disbarment. His documented public and professional history centers on a respected legal career spanning appellate work, government service, and a specialty niche in equine law. It's worth pausing here and being direct with you. Roach's case is different from every other name on this list. The publicly available record of his career does not document the kind of criminal charges, bar discipline, or judicial removal proceedings found in the other 9 cases we've covered today. His path through the legal profession, from a top Supreme Court clerkship to a young appointment on Kentucky's highest court, to a long and apparently well-regarded career in private practice afterward, reads as a standard, accomplished legal career rather than a scandal. If you came across his name expecting a story of corruption, the honest answer is that the record does not support one, and it would not be right to manufacture a controversy where the documented facts simply don't show one. Closing. 10 names, 10 robes, 10 very different paths that all ended the same way, with the public finding out that the person meant to protect them had been using that same protection to serve themselves instead. Some took cash for kids. Some stole evidence they were sworn to guard. Some used decades of community trust to silence people who had nowhere else to turn. And some simply let personal ambition and unchecked discretion quietly bend the outcome of case after case until somebody finally noticed. What ties almost all of these stories together isn't the specific crime. It's the amount of time it took for anyone to catch it. Pennsylvania's own Judicial Conduct Board admitted it received 4 separate complaints about Michael Conahan and never investigated a single one of them. Investigations into Ciavarella and Conahan alone stretch back to at least 2006 before charges were ever filed in 2009. Dawn Gentry's alleged conduct built for years inside her own courthouse before a single former employee came forward. Tim Nolan spent decades in public life before one woman finally walked into a police station. Complaints were filed and ignored. Investigations stalled for years. Entire communities trusted a title on a door long after that title had stopped meaning anything. It is easy to watch a video like this and treat each of these names as an isolated bad actor, one rotten exception in an otherwise trustworthy system. But look at how many of these cases only came to light because of a single outside factor, a federal wiretap in an unrelated case, a disgruntled former employee willing to talk, a local reporter who kept asking questions nobody wanted to answer, a blog publisher who happened to catch an anonymous online post. Take any one of those away, and it is entirely possible some of these judges finish out full careers on the bench, never investigated, never removed, never held to account for any of it. If there's one thing worth sitting with after a story like this, it's that accountability for people in positions of power rarely comes fast, and it almost never comes on its own. It comes because someone, usually someone with very little power of their own compared to the judge sitting across from them, refused to stay quiet. A teenager's mother who kept pushing, a former court employee willing to file a complaint, a juror who would not agree to a death sentence just because everyone else in the room wanted her to, an attorney who filed one more appeal after being told to give up. None of these people had a robe. All of them, in their own way, are the reason any of these stories ever became public at all. Thank you for watching. If you want more real cases like this, let me know in the comments which judge stood out to you the most.